So is this ban a violation of fundamental rights, free choice, or has discipline been imposed? Is a uniform essential to equality? Is the hijab really an essential religious practice for Islam? Does the ban hit the right to education? These were all questions that were raised in the court. What were the responses? We'll go to those one by one. But joining me therefore on the show tonight are people who've closely tracked this case. K.V. Dhananjay is a senior advocate, from Karnataka, and is someone who had raised this issue in its original form when the ban was imposed by the Karnataka government. I'm also joined by Vivek Subba Reddy, Senior Advocate, High Court of Karnataka. He's also President, Advocates Association of Bengaluru. And by Dushyant-The, who appeared for the petitioners, Senior Advocate, Supreme Court, appeared for the petitioners. So Dushyant-The, let's come to you first. Since you argued in the court and we've seen a clear split verdict, Justice Gupta is very clear that a hijab is a reasonable restriction that a school can put because a school has the right to impose a sense of uniformity, and secularism, he says, does not mean that any religion is given any preferential treatment when it comes to a dress code. On the other hand, Justice Dhulia believes very differently that right to religion under Article 25, right to freedom under Article 19 allows people to wear the dress they choose to. How do you see two such contrasting views from two judges, Mr. Dave?
Well, it's not so easy an answer, but I can definitely say one thing with greatest respect to Justice Gupta, whom I really admire, that he is completely wrong. I don't think he has understood the Constitution. I don't think he understands the scope and ambit of the freedom of religion that the constitutional framers, provided in our Constitution. I, in fact, cited the Constitutional Assembly debates, which before the bench. And throughout the debates, the members after members of the Constitution Assembly, including T.T. Krishnamachari, Kanayalal Munshi, and Santhanam, many others, repeatedly said that Article 25, which was old Article 19, is an article of toleration. And they said that we must therefore allow every kind of a belief by any religion, and not just a belief, but the conscience of the people who profess the religion and the practices which are followed by them. Now that's precisely what the Supreme Court's 7-judge bench has earlier said in Shirur Math's case, that these are all expressly protected. Therefore, I don't think that Justice Gupta's view is at all in consonance with the Constitution, in consonance with the previous judgments of the Supreme Court. And I think I would much rather say that Justice Dhulia has taken an eminently just and legal approach, and I commend that for acceptance before the nation.
No, you're emphasizing Article 25, freedom to practice your religion and hold religious beliefs. However, Justice Gupta has said, and I quote here, government order, that's the Karnataka government order, promotes uniformity, encourages a secular environment, order in tune with the right guaranteed under Article 14 of the Constitution. Therefore, he claims that the right to equality is strengthened if you have a uniform dress code, and it is a reasonable restriction on Article 19 as well. That's so, there are two different, while you say that Justice Gupta has got it wrong, his proponents would well argue that he too is following a constitutional principle.
No, I don't think I can agree to that view of Justice Gupta, for the simple reason that right to equality does not take away freedom of religion. Freedom, every article, of the Constitution, the fundamental articles, spring into being all the time. And therefore, you can't say that one article is at the cost of another article. Certainly not. So, giving that into, play, I personally feel that freedom of religion does not stop at the school gate. The freedom of religion, in fact, continues for every child who is studying in a school. And as I had told judges, that look, nobody is saying that there should be no uniform. the color of the hijab was also the color of the uniform of the colleges. And therefore, these are not, this is not military you are dealing with. This is schools where, every child must have a right to express his or her freedom. And if you try to curtail that by saying that, oh, we have a right to put some kind of a restriction in the garb of equality, I don't think equality principle can be evoked to the extent that they have done. Okay. So I honestly feel that Justice Gupta has gone terribly wrong in the view that he has taken.
Let me bring in Mr. Reddy, because Mr. Reddy opposed what you're saying and he supported what the Karnataka government does. Mr. Reddy, how do you respond to what Mr. Dave is saying? That he seems to give primacy to Article 25, as it would seem Justice Dhulia did, freedom to practice your religion. Therefore, if I choose to wear a hijab, that is my right under Article 25. It does not interfere with someone else's rights also. By wearing a hijab, I'm not interfering with someone else's rights, and therefore I must be entitled to wear one. Your response to what you heard, which in a way Justice Dhulia was challenging what the Karnataka High Court said.
Yes, Rajdeep, I think there are two perspectives to this. First of all, what happens within the campus is to be controlled by the government. The government has a stake in ensuring uniformity within the campus, in ensuring that religion does not become a symbol of invasion or a symbol of influence within campuses.
Right.
I think this is an essential issue which the state, in which the state has a stake, and the state has to regulate. And it is from this perspective that Justice Hemant Gupta said that there must be equality of uniforms within the campus. And he is absolutely right, because throughout the length and breadth of this country, Supreme Court lays down the law for the country. Throughout the length and breadth of the country, we have issues as to what should be the uniforms in campuses. So it is not the religion that prescribes the uniform in the campuses. It is the government that prescribes what should be the uniforms. Therefore, the government is absolutely right. The government has traced its powers to the right sections while drafting these orders. This is number one. Second thing is, coming to Mr. Dushyant Dave's argument regarding right of conscience and freedom of religion, freedom of conscience and religion. I think here the essential religious practice question comes as to whether it is freedom of conscience per se, or an essential religious practice which reflects the core belief of a religion, and whether that core belief of that religion has to find reflection through the wearing of hijab or through talaq or through various other things. And on this question, Justice Hemant Gupta has come out very clearly and said that it is not an essential religious practice, and therefore it does not attract Article 25. I think this is where Justice Dhulia, Sudhanshu Dhulia, has completely missed the point. The Karnataka High Court, with the three judges, a full bench of the Karnataka High Court held, including a learned judge, Justice Kazi, held that it is not an essential religious practice. And that view is reflected in the views of Justice Hemant Gupta. And this is where Justice Sudhanshu Dhulia wholly missed the point. And I think he is wrong on the perspective of law, because even in talaq case, it was held that it is not an essential religious practice, something which reflects the core belief of a religion. So you're saying
Article
essence of a religion.
Sure. So you're saying Article 25. This was debated in the court whether it is limited to what constitutes essential religious practices. Mr. Dhananjay, interestingly, one of the arguments that was made even in the Karnataka High Court by the government of the day, saying many of these schools did not make hijab. The girls in many of these schools did not wear hijab till a couple of years ago. So if it was an essential religious practice, why were they not wearing it all these years? Suddenly they wear it and a ban is imposed, and when the ban is imposed, then the petitioners argue, no, it's an essential religious practice. The argument they are making is it is not an essential religious practice. Therefore, for example, it can't be compared with a kada, which Sikhs claim is an essential part of their religious belief system. Is that argument settled now, or do you believe that is one of the core arguments that will now go to a wider bench?
Well, it was unnecessary for the girls to show or to prove that they were wearing hijab much prior to that, because the right to wear a hijab doesn't really depend on having worn hijab in the past year or 10 years or so. So that is not how the law would have, that's not what the law would have expected. So neither was the government able to show or prove that they were not able to wear a hijab, because that question, answering that question would have made no difference whatsoever to the eventual outcome. The government of Karnataka came out with this order, and the touchstone of that order was courts have spoken according to the government, and courts have unanimously said that wearing of a hijab, can be curtailed in educational institutions. Once said that the hijab ban would have the effect of increasing Muslim girl students' attendance in school. So their touchstone was that there is judicial unanimity, and that attitude obviously takes a huge setback today, because the Supreme Court has spoken. An eminent judge of the Supreme Court has said that this policy of the government is illegal, is unconstitutional. And should you read Honorable Justice Sudhanshu Dhulia's judgment, you will find that the judge has asked very simple questions that a common person that will easily resonate with the common person. The questions that the judge went on to ask is, who is in any way harmed should a girl wear a hijab? And then the judge goes on to ask, what happens when we see that girls have, a few girls have stopped attending schools, and few girls have even missed out their examination? And is that not a matter of greater concern than other constitutional issues and religious issues and legal issues?
No, but those are practical. No, those are practical questions, Mr. Dhananjay. Those are not constitutional questions. Those constitutional questions will eventually have to be answered as well. Whether this constitutes an essential religious practice or not is a question that is still blowing in the wind. There are Islamic countries in the world that do not impose, that do not make hijab mandatory. So why should...
Well, I think the way to look at it is this. The government has vast powers under the Karnataka Education Act. If the government tomorrow decides, and the Education Act very clearly says that the government will set the syllabus and prescribe textbooks. If the government tomorrow says that they don't want to include the 1905 Bengal partition in its history books, and somebody who questions that in courts, it's possible that all the courts in the country might say that the government has given the prerogative to decide on syllabus in history textbooks, and the government has decided what it has decided, we would not interfere. So the fact that courts would uphold the government's powers does not in any manner tell you what the government did is good educational policy. There is nobody within the government of Karnataka, there is no officer within the Department of Education who would come forward and say that this uniform rule that we have brought in, which bans hijab, is a rule that is worth it, even if it would lead to some girl students missing out on school or on education. And that is why I've always been pointing out that a circular being debated in the High Court and in the Supreme Court for weeks or months just does not make any sense when you consider how other similar democracies deal with it. There has to be a statute. If you wish to ban something, if you wish to take away somebody's right, you just can't do that through a circular. The Karnataka Education Act does not even answer a simple question like what would a private school do when a parent does not pay the fee of the child. And courts have said, look, this statute does not talk of expulsion. This statute does not talk of suspension. So if you are a private school and if a parent refuses to pay the fee, please don't terminate the child. Rather, file a suit against the parent to recover the fee and continue the child in school. This is the Karnataka Education Act.
I think Dhananjay misses the point here.
Yeah, go ahead, Mr.
Point here.
Yet, Mr. Reddy.
Just a short intervention. While making this law or while drafting this circular, government had a policy behind it. It is not Dhananjay's personal perception to replace that policy. But of course, we are all testing the constitutionality of this policy.
What was the policy? What according to you drove this policy of the Karnataka government in the first instance?
The government has not broken any policy. It has been the consistent policy of the government since 2013, when it was prescribed that there has to be uniformity there has to be equality in uniforms. There has to be sameness in uniforms. So this was done through a very clear structure. There was a school committee. And the school committee was headed by the local MLA. And it had been drafted by this committee. It was not the government's personal policy. And this had been in vogue since a long period of time. And if Dhananjay has a personal perspective about it, so be it.
Okay,
this is a policy regarding uniform.
You're saying uniformity of dress code was part of the Karnataka government's policy since 2013. There is also the question that the court in a way wrestled with these two judges, freedom of choice, Dushyant Dave. You know, you've got Justice Dhulia saying freedom of choice. Each individual has the right, he or she, to decide what she wants to wear. But that's a very dangerous argument, because there will be others who will say your parents are coercing you into wearing a hijab. So where is the real freedom of choice for a 8, 9, 10-year-old girl? Now this question also seems to be approached very differently by Justice Gupta, who is very clear that it's the school that decides and not the parent. Do you believe that this too will have to be settled by a wider bench, the notion of freedom of choice?
I must tell you something shocking. Both Justice Gupta and my dear friend Vivek Reddy have completely lost sight of the fact that the very government of Karnataka had issued a circular for the academic year 2022-23 expressly providing that uniform is not compulsory, and anybody insisting on wearing of uniform in colleges will be penalized. This circular was placed by me before the bench. The judges were shocked. They asked the government to respond. The government failed to respond. So that's the first thing. Secondly, Vivek is rightly saying essential practice. Essential practice argument was rejected by Constitution Bench in 1954. In Shirur Justice Mukherjee speaking for the court said, and I'll read one line, Learned Attorney General lays stress upon clause 2A of the article, and his contention is that all secular activities which may be associated with religion but do not really constitute an essential part of it are amenable to state regulation. Now judges respond to that. The contention formulated in such broad terms cannot, we think, be supported. Now this is what Supreme Court said in 1954. Supreme Court says very rightly that matter of religion is a matter of personal belief, personal conscience. We are not talking about anybody forcing here. It is a voluntary act of a child to wear a hijab, like a Sikh child would wear a turban. Constitution doesn't protect a turban. It only protects kirpan, because otherwise arms are banned. So you may have a tilak, you may have a Mangal Sutra, you may have a Rakhi, as I have. Every one of these is a religious symbol. In fact, recently I read somewhere that Karnataka government has said that students in school should come with a Gita in the school. What is this? See, this is nothing, Rajdeep, but marginalizing the minority community and to create an atmosphere of hatred in this country so that the Hindu votes are consolidated and BJP benefit. Sadly, there is no other purpose. There was no policy till this year. Why is it that for 75 years BJP has been in power earlier? Why is it that it never thought of it earlier?
Vivek?
So it is only when elections are round the corner.
I'm sure that
just a sec, Vivek, I didn't interrupt you.
Mr. Dave, you had your word. Let him respond.
Just when the elections are round, the corner, BJP thinks this as it is doing in Gujarat, in Garbas, or now it is doing here in Karnataka. Nothing else.
Okay. Mr. Dave, you made your point. Yes, Mr. Reddy, respond to that. That there is a political angle to it.
I like the way Mr. Dave is escaping the moot question on essential religious practice. See, Shirur Mutt's case, which Mr. Dave pointed out, and I was listening to it, I think these are general brushes adumbrating the concept of what is an essential practice. But Mr. Dave must realize that in Harif Qureshi's case, a similar constitution bench judgment in 60s, where the issue came up as to whether cow slaughter or eating of beef was a way of life, was an essential religious practice. The Supreme Court turned down this question and said it is not an essential religious practice. A similar question came up in the Talaq judgment, where Justice Nariman said that Talaq is not an essential religious practice. Well, merely because in 1950s something was stated in Shirur Mutt's case does not prevent the Supreme Court in testing the core beliefs, the fundamental beliefs of a religion as to whether it is an essential religious practice. And the Supreme Court has tested it time and again. And these are not political questions, Mr. Dave. These are essential constitutional questions which are being debated in the court. And what the state has in stake is that it has to ensure campus uniformity. Mr. Dave may personally not like it. Well, that's his problem. But campus uniformity is something in which the state has a stake. The state government has a stake. Because it has to ensure in all secular countries, we ensure that the campuses are kept away from invasion of religion. Well, the state has a stake in that. Okay. And I'm sure that if it is not an essential religious practice, it is all the more clear that it should not come into this. So the moot question is, Mr. Dave, why did it suddenly crop up in 2021? Where was it lingering all these years? Unless and until there has been an attempt from some quarters to infuse this mischief for which Mr. Dave is arguing in the campus.
Let Mr.
That's
Dhananjay
specifically put forth in Kundapur and in Udupi. And that is what the courts have taken judicial notice of.
Let Mr. Dhananjay respond to that. Vivek, let Mr. Dhananjay respond to that. There are two views of looking at it. Suddenly in 2021, you have women girls who are not wearing hijab, coming to schools wearing hijab. So there are those who will argue that Islamist organizations like the Popular Front, its campus front, were pushing young girls to wear hijab. That this was not out of free choice. They were also making a political statement.
Well, I am also the legal counsel of the largest body of private schools and colleges in Karnataka. Its name is KUSMA, Karnataka Unaided Schools Management Association. I'm the legal counsel. I've been the legal counsel for the last 12 years. And I can tell you that in private schools and in government schools and colleges, hijab was being worn. And we have more exposure to the Karnataka Education Act than any advocate within the government. So it is with that sense of responsibility I would like to point out that hijab was always being worn in some schools, some colleges, and nobody should be disputing that. Now we will come to the other issue, which is the government kept on saying that it was forced to take this view because in some schools and colleges, children started wearing saffron shawls. Now, it's very surprising that neither did the High Court of Karnataka nor even the Supreme Court asked the genuineness of that movement. Did anyone go to the High Court of Karnataka or to the Supreme Court to say that the order passed by the schools and colleges had the effect not merely of prohibiting hijab, but also prohibiting saffron shawls? Did anyone go to the court to say that this prohibition of saffron shawl would hurt their religious belief or anything? Nobody went. And that largely, if you go by common sense principle, would tell you that this was more like something that was staged. And it's unfortunate that the High Court of Karnataka and also the Supreme Court did not stress on that aspect. They ought to have asked pointed questions to the government and said, you were citing the saffron shawl as a disruption for which you had to come out with a hijab ban. How is it that people who wanted to wear saffron shawls and who are no longer permitted to wear don't come to the court to agitate it?
This is not an answer to the sudden manner in which hijab came in. This is not an answer, Mr. Dhananjay, to the sudden manner as to why hijab issue came to the forefront only in Udupi and Kundapur. Not anywhere else.
By the way, in private schools and college, and this uniform concept,
by the way,
Rajdeep,
the richest schools. Saffron shawl.
Let Dhananjay, yes, Dhananjay.
Rajdeep, the richest schools, by the way, in Bangalore, which charge upward of 5 lakhs for nursery and Montessori, they don't have a concept of a uniform at all. The concept of uniform never populated the discussion around the Education Act in the last 75 years. I want to tell you that.
Let's leave it there. You know, as we've seen, these are contentious issues, not settled fully by the court yet. The interesting thing, Mr. Dave, Mr. Reddy and Mr. Dhananjay, is that the court will now, this will go to a larger constitutional bench where issues like essential religious practice or not will have to be clarified, which has not really been fully clarified by the two judges, particularly Justice Dhulia, who's focused more on girl-child education and the need not to provide the girl-child unimpeded education. But I appreciate having three fine lawyers joining me to tell us in a way where they stand. Yes, Mr. Dave, you want a final point? Yes.
Yes, I want to say one thing, especially to my friend Vivek, that Karnataka in recent times has a history of targeting the minority community. This is part of that. Take, for example, the Idgah ground in Bangalore, where suddenly after some 200 years or 400 years, they wanted to allow, Ganpati Visarjan or Ganpati Pujas there, which was exclusively held by the Muslim community. Take, for example, Mr. Reddy, don't interrupt. Please.
Easy,
I don't
easy,
interrupt
get
you.
tense.
Okay, then,
Don't
Vivek,
get
I'll let you
terrible
respond
habit.
to it. Vivek,
You
I'll
have
let
a
you
terrible
respond. Let
habit.
me finish.
This is
Control
BJP.
your BP.
BJP wants to stop everybody from
Vivek,
talking.
No,
Don't
Vivek's
Doesn't
not being
speak well
unfair.
of
There is
you.
no necessity.
I
This is a
respect you.
friendly
I
chat,
showed you respect.
Mr. Dave.
Show some
This is a
respect.
friendly chat.
No,
No need
sorry,
to get
don't
tense
interrupt.
on national TV.
Okay,
The
whole
Vivek,
nation
I
is
will let you
watching.
respond.
Horrible
but
habit you have.
Vivek, yes.
You can't
Mr.
tolerate
Dave, make your point.
independent view.
Mr. Dave, make your point.
Yes. Take for example, in recent times, Muslims selling, flowers and, other things in temples were disallowed from selling it. Karnataka is somehow doing this, deliberately to target. Rajdeep, 5,000 years of history of liberalism this country has. It doesn't need this. Let any child wear whatever it wants to. Why not? Do you have the courage to stop a Sikh child from wearing a turban? You
Okay,
don't have the courage because you have seen the militancy of the Sikhs.
Okay,
Don't force the minority community to militancy.
Okay.
You may say, Rajdeep, I don't agree with you.
That can't be a reasoning in a court of law, though.
I don't agree with you that PFI has encouraged it.
Rajdeep, can I
You are
just come in?
pushing young Muslim men
You
and
need
women
to allow
towards
me to respond to
radicalism
this.
by this kind of action.
Okay, Mr. Dave, you made your point. Yes, Mr. Reddy, now you can respond. Dushyant, you made your point. Yes, Mr. Reddy, now you can
Mr. Dave,
respond.
I'm sorry for having interrupted you. Anyway, the issue is this. The point is that you talk about liberalism. There was an existing school policy. Mr. Dave has to answer in this
There has been no policy,
hijab
Mr.
issue.
Reddy.
No, now you are intervening with him, Mr. Dave.
Please answer a fundamental question as to why some children came in front of campuses asking for hijab, which was not there all these years. Who instigated this? Who instigated this? So don't say that the government was responsible for all this. Please know the facts.
Okay, we are now...
Please know the facts. These are basic facts.
Okay, I'm going to leave it there. As I said, these are constitutional questions that will also have to be addressed. We dipped into the politics just now, and that's where I'm going to turn in a moment, but I appreciate my three guests joining me today.